City of Madeira Beach Code Enforcement hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 18 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city clerk. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owner will then be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city clerk will swear in any witnesses.
Please stand and raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth? Thank you.
Excellent. The first case on the agenda today is case number 385. The respondent or property owner is Ronghyu Yu, and the property location is 812 Bay Point Drive, Madeira Beach, Florida. Is the city ready to proceed?
Yes, we are, Your Honor.
All right, go ahead.
The city calls Code Enforcement Officer Holden Pinkard. Holden, could you please describe the notice of hearing that was provided and by what method it was provided, citing to the page numbers that are in the magistrate's evidentiary packet?
Sure. Notice was given regular mail and certified mail. The mailings are, and the property was also posted.
Was the address sent to the address of the violation?
Excuse me, city attorney, can't hear you on the mic. Thank you.
The address to which the notices were sent, were they the same address as the address of the home in violation?
Yes, it was sent to the owner mailing address that's on the property appraiser's website, page 37.
Is that the same address as the violation?
Yes.
And does the home appear to be occupied?
Not at this time, no.
And could you please describe the nature of the violation and if anyone was present when you inspected the property?
Sure. This violation is actually rather old. The initial inspection that was done was back in April of 18, and we received a complaint that some work was going on at the property, and after being allowed on the property by one of the workers to be brought in the back, the bathroom, or a bathroom, was being built in the garage on an elevated home. So a stop work order was issued that day, and I believe three days later, April 27th, we received a building permit application that was reviewed and denied by building and planning for FEMA-related reasons.
So to summarize, you went and inspected the property, noticed there were ongoing work without a building permit, and then they applied for a building permit 3 days, and then it was denied.
Right.
They applied on 4/27/18, and it was denied on 5/2/18.
Right.
And it's been over a year?
Correct.
Okay. And they've not come in for another building permit?
No, I have not received any response from them via email, phone, or, yeah, just via email or phone. I haven't received any response from them.
Is it an owner-builder, a building permit application?
I believe the homeowners were doing it themselves to begin with, but we told them that they would need a licensed contractor to do the work because they weren't homesteaded. It was a income property.
And they've listed in their building permit application, all state quality, illegible LGC, Olivier Gomez?
I believe that's what that says, yes.
Did the contractor, Olivia Gomez, call for a building inspection at any time?
No, no inspections would be done because we weren't able to issue the permit. When it was first denied back on May 2nd by our building official, I think there was some correspondence between the planning director and the building official, page 29 of the packet. And everything just kind of faded off. So there hasn't been any movement on it since, and we just want to make sure that this property's in compliance, whether it was done and needs to be removed. That I'm not sure what the current status of it is right now.
On page 35, there's a Pinellas County Construction Licensing Board, a certificate for Olivia Gomez with the information. Do we know whether that contractor was doing the work or they were simply placed on the permit application that was submitted after the fact, after you noticed work had already begun?
I don't believe Olivia Gomez and that company, Allstate Quality Construction, was the contractor doing the work. It's my understanding that the homeowners went out and found a licensed contractor because they were doing the work themselves originally.
And to your knowledge, do the owners speak English?
Yes, I believe so.
And have they tried to contact you about today's hearing?
No, I've received no response from the notices.
Your Honor, that's all the city has at this time. Actually, we have a little bit more. What is the remedy that you're seeking in this case in terms of a daily penalty and any actions to bring the property into compliance?
Given the, whatever the special magistrate's order comply by date is, I would say the $250 a day, and then additionally it'd be more administrative, but we'd probably have to, pursuant to section 9483, have our planning and zoning director see if we can remove their respective properties' eligibility for flood insurance.
Okay, and that would be done in a separate letter to FEMA that
Right.
would attach the special magistrate's order finding the property to be not in compliance.
Correct.
And would 30 days be a reasonable time in which to apply for a building permit?
I think the 30 days would be adequate. Just make sure that they remove it and don't build it.
And would you also be seeking the ability to perform an inspection of all work that's been completed at the house?
Yes.
And after the fact, building permit fees for any after the fact building permit work?
Right. Well, if it was an after the fact permit, we would collect the fees from that. They'd be 5 times.
Okay. 5 times the normal amount is the after the fact fee?
Correct.
Okay. I think that's it, Your Honor, at this time. If you have any questions for us, let us know.
All right, Mr. Pinker, just a couple questions. If I understand the nature of the violation under 86-52 is the new construction of a bathroom and the associated plumbing on the first floor that would require a permit. Is that correct?
Correct.
I just want to make sure in looking at it that this is, the cost of repair or modification would exceed $500.
Does the work that you witnessed look like it was over $500 worth of work?
Yeah, your typical shower bathroom remodel would be around 5 to 10,000.
And for this type of remodel, I take it would require an inspection and a permit?
Correct. This is looking in from the rear, from the backyard.
Okay, what are you looking at?
What page?
Page 18. So that's almost as if you were on the back patio by the pool looking in. So what was a garage, their intention was to build a bathroom underneath the stairs, and then the application that they submitted on page 23 and 4, drywall, let's see here.
And bathrooms under the FEMA-based flood elevation are not permitted in this matter in the home?
That's how I understand it, right?
Okay.
All right, and I take it, the reason I'm asking these questions, I just want to make sure this doesn't fall within any of the exceptions in 86-52. I take it that a permit would be required for this work because it's something beyond just something that's of strictly cosmetic in nature, correct?
Correct. Clear, it would exceed the $500, and the work that's done would require several different inspections.
And are the flat slab work more than 50 square feet? And more than a strictly cosmetic nature, correct?
Right, it wouldn't fall under any of the no permit is required section.
All right, I think I understand that violation and the basis for it. I understand is there a second violation under 94-83 of the code?
No,
think-
I'm sorry, go ahead, Ralph.
You go first.
Okay. Yeah, I wasn't sure whether, it doesn't look like that particular code could be, you could violate it. It's more of an administrative function.
Okay, so the city is essentially asserting one code violation.
Yes, and if there's a violation, then the building official will go ahead and submit the information to FEMA, which would remove the respective property's eligibility for the flood insurance coverage through the NFIP, so that we keep our CRS rating for the city in good standing.
All right, I understand. I'll go ahead and accept into evidence in the record exhibit number 1, which will be the agenda and pages 1 through 38 of the agenda packet. All right, is there anything else the city wants to present by way of evidence or argument?
Not at this time.
Not at this time, Your Honor.
All right, and looking at the room, I do not see anyone here on behalf of the respondent or property owner. Also, there are no members of the public here, but we will open it for public comment. Seeing no public comment and no one from the respondent or property owner having showed up to present any kind of defense, is there anything else the city wants to tell me?
Not at this time, Your Honor.
All right, I'll go ahead and find that the property is in violation of Section 86-52. Give the property owner 30 days to comply from entry of my order. Compliance will be by either obtaining the permit or removing the unpermitted structure. If the property is not brought into compliance within 30 days, there'll be a $250 a day fine thereafter. All right, that concludes the hearing on case number 385. Is there anything else before me today?
No, Your Honor.
No,
That's it.
sir.
All right, that will conclude today's hearing. Thank you very much.
Thank you.